That's Thomas Sanford, 2026 CF 5A. Ms. Brockway for the state, Mr. Cianci for the defense. Thomas Sanford.
We still have Ms. Walker, too.
Yeah, Ms. Walker is still.
Walker.
Yes, Ms.
So we have another one too?
Alicia Walker.
Give that to the judge. Thank you so much.
On Mr. Sanford's case, I would note that I was the one that asked for the continuance last week when this was scheduled for Judge Ferrero's courtroom. I was told that upon apprehension he was bitten by the canine and couldn't be brought over because he was getting treatment for those injuries, but I was the one that requested the continuance to this date.
Okay. So we have Mr. Sanford here, correct? Okay. All right, so Ms. Brockway?
Yes, Your Honor. In the case of Mr. Sanford, the state has proceeded under two separate portions of the statute. Either that there's a substantial probability that he poses a threat to harm to the community and committed this offense, which is a dangerous offense, that being aggravated battery, or that he was on probation at the time of the offense. We've attached the probation paperwork. We've noted for the record that he currently is on no bond for probation, as ordered by the court, and we would ask that the court grant the motion for pretrial detention.
Mr. Cianci?
Your Honor, I just would note for when I read the arrest report and after speaking with my client, it does appear to me that this case fits the profile of my client being attacked by 3 people in the residence that he owned and that they were guests in. If you look at the report, it appears as though victim 2 states that he heard my client arguing with victim 1, who is victim 2's mother, and then victim 2 comes up from behind Mr. Sanford, and a melee ensues. It appears as though everyone's sort of saying this same sort of story, and I think once we learn who the people are in my client's house, it'll become apparent to hopefully everybody that he is the victim here, and that these 3 people are the ones that are, driving the narrative here and have had my client kicked out of his house so that they can basically take over the premises. My client is an honorably discharged veteran. He's in veterans housing. In the end, I think if we look at him and we hear about what happened to him and he's taken into custody, he was hurt much more than any of the other people that were there that day. I've got investigators from my office going out and trying to verify what I believe happened here, trying to contact my client's landlord, trying to figure out who the victims are here. I don't believe, Your Honor, that my client is a danger to the community. I believe that hopefully once we get to the facts, he'll be vindicated and it will be shown that he was immune from prosecution, as this was self-defense. If this was a dangerous weapon, I think that there'd be more injuries here than a 2-inch scratch on someone's leg. I cannot, my client is on probation. He's on probation for possession of controlled substance. I can't get away from that, so I believe that that would be a basis for holding him at pretrial detention, but I don't believe that this court should find that he's a substantial danger to the community. And I hope that once we look into this further, he'll be, exonerated on all charges.
I've read the minimus, and I agree that the fact pattern might be subject to some interpretation. None of us were there.
Nope.
But I do think at this point what I'm going to do it's appropriate for me to do. The officers who were on the scene who invested the case and were de minimis, I'm going to take them at face value as to what they were told by the witnesses when they were there. So I do find that there is probable cause for an aggravated battery to be charged here. And also that he's currently, under the other prong of the statute, he's currently on probation, so he would qualify to be held without a bond simply on that factor alone, since he's committing this offense while he's allegedly on probation. So I'm going to grant the state's motion for pretrial detention, finding that he represents a clear and present danger to the community, and there is no other way to alternatively ensure the safety of the community for this qualifying offense, and also that he was on probation at the time the events occurred. So we're going to hold you without bond, sir, until your case can be resolved.
Thank you, Your Honor. State will prepare an order.
Thank you.
Thank you.
And Your Honor,